Hello everyone, my name is Marcellino and I'm from Class A, and today I will discuss two recent and highly relevant intellectual property right cases that have attracted global attention. These cases demonstrate how intellectual property rights continue to face new challenges in the digital age, especially with the rapid development of technology, artificial intelligence, and online platforms. Before we move on to the copyright case, we must first understand what is copyright. Copyright is a legal protection granted to creators of original works, such as illustrations, graphic designs, photographs, music, films, literacy works, and lastly, software. Copyright provides creators with exclusive rights to reproduce, distribute, publish, and profit from their creations. The main purpose of copyright is to encourage creativity while protecting creators from unauthorized use of their works. So now, we're going to discuss about New York Times versus OpenAI and Microsoft. One of the most significant copyright disputes in recent years is a lawsuit filed by the New York Times against OpenAI and Microsoft. It's so popular and significant to many people because even universities around the world are making articles about it. Universities like Harvard Law School, Columbia Undergraduate Law School, and many more. Even law companies that are not correlated whatsoever are discussing this case. There's even a file made by one of the law company that documented some of the trials in a PDF file. It started in December 2023. The New York Times sued OpenAI and Microsoft, alleging that millions of copyrighted news articles had been used without permission to train AI systems such as ChatGPT. According to the lawsuit, the AI model was capable of generating responses that closely resembled New York Times content, potentially reducing traffic to the newspaper's website and harming its business model. The New York Times argued that OpenAI benefited commercially from copyrighted content without obtaining a proper license or compensating the creators. OpenAI then responded by claiming that AI training constitutes transformative use and may fall under the doctrine of fair use. The case remains ongoing and is expected to become one of the most influential copyright cases in the history of artificial intelligence. Here's the timeline of the case. At first, it started in December 2023. The New York Times filed a copyright infringement lawsuit against OpenAI and Microsoft, alleging that its copyrighted articles were used without permission to train AI models. In 2024, OpenAI denied the allegations and argued that AI training may qualify as fair use. Both parties entered the discovery phase to exchange evidence. Then, in March 2025, Judge Sidney H. Stein allowed the core copyright claims to proceed, rejecting OpenAI's attempt to dismiss the main parts of the lawsuit. In April 2025, the case was consolidated with other major AI copyright lawsuits in the Southern District of New York. At last, in the current status in June 2026, the lawsuit is still ongoing. No final judgment has been issued regarding whether OpenAI's use of copyrighted content for AI training constitutes copyright infringement. You might be asking, why is this case important? Well, this case raises several critical questions. First, can AI companies use copyrighted works for training purposes? Second, should creators receive compensation when their works are used to train AI? Lastly, how should copyrighted law adapt to emerging technologies? The outcome may establish legal precedents for the future development of artificial intelligence worldwide. Here are the legal bases for copyright that are connected with the case. First, If we see from the Indonesian legal framework, copyright protection is regulated under Undang-Undang Republik Indonesia Nomor 28 Tahun 2014 tentang Hak Cipta. Relevant provisions include Article 1 that says defines copyright as an exclusive right automatically granted to creators after their work is expressed in a tangible form. Article 9 says grants creators exclusive economic rights to publish, reproduce, adapt, distribute, and communicate their works. Lastly, Article 113 that says provides civil and criminal sanction for copyright infringement. Anyone reproducing or commercially exploiting copyrighted works without authorization may face fines and imprisonment. Next, if we look at the international legal framework, this case is also connected to Berne Convention for the Protection of Literary and Artistic Works. The relevant provisions are Article 2, Number 1, that protects literary and artistic works, including books, articles, writings, and journalistic publications. The New York Times article fall under this protection. Article 8 grants authors the exclusive right to authorize translation of their works. Article 9, Number 1 grants authors the exclusive right to reproduce their works in any manner or form. The New York Times argues that AI training involves copying copyrighted material during dataset creation. Article 9, Number 2 provides limited exceptions for reproduction, commonly known as the three-step test. The World Intellectual Property Organization Copyright Treaty, also known as WIPO, is also connected to this case. The relevant provisions are Article 1, reverb protection under the Berne Convention. Article 8 grants authors the exclusive right to communicate works to the public through digital networks. Lastly, Article 11 requires legal protection against circumvention of technological protection measures. These international agreements require member countries to protect creators' rights and provide legal remedies against infringement. Next, we are going to discuss about the trademark infringement case. But first, we need to understand what is trademark rights. A trademark is a distinctive sign used to identify goods or services from a particular business. Trademarks can include brand names, logos, symbols, slogans, and finally, product packaging. Trademark protection helps consumers identify authentic products and prevents confusion in the marketplace. The case study that we are going to discuss for trademark infringement is the case of OpenAI versus OpenAI trademark dispute. A recent trademark controversy involved OpenAI, the developer of ChatGPT. Another company had previously registered and used a similar name, OpenAI, creating confusion among consumers and businesses. As OpenAI expanded globally, questions emerged regarding ownership, branding rights, and trademark protection in different jurisdictions. The dispute highlighted the importance of secret trademark early, especially for technology companies operating internationally. The central issue was whether the similarity of the names could mislead consumers into believing the companies were affiliated. Trademark law seeks to prevent precisely this type of marketplace confusion. Here's the timeline for the case. At first, it started in March 2015, where an entrepreneur guy, Ravin, acquired the domain OpenAI and began developing an AI-related project under the name OpenAI. In December 11, 2015, OpenAI was publicly launched by founders including Sam Altman, Elon Musk, and others. The following day, Ravin applied to register the OpenAI trademark. Next, 2023, OpenAI filed a federal trademark infringement lawsuit against Ravin and his company, alleging that the use of OpenAI was likely to confuse consumers and falsely suggest an affiliation with OpenAI. 2024, a federal court granted OpenAI a preliminary injunction, finding that OpenAI was likely to succeed on its trademark claims. July 21 until 22, 2025, the U.S. District Court for the Northern District of California ruled in favor of OpenAI. Judge Yvonne Gonzalez-Rogers found that OpenAI artificial intelligence use of OpenAI infringed OpenAI's trademark rights and permanently prohibited the defendants from using the mark. The court also invalidated Ravin's trademark registration. 2025 until 2026, the defendants indicated that they intended to appeal, but the July 2025 ruling remains the most significant judgment in this lawsuit. Why is this case important? Well, this case demonstrates that brand identity is a valuable business asset. Similar names can create consumer confusion, and global companies must protect their trademarks across multiple countries. For designers and brand developers, trademark registration is an essential step in protecting brand value and market recognition. Here are the legal bases for trademarks that are connected to the case. First, if we see from the Indonesian legal framework, trademark protection in Indonesia is regulated under Undang-Undang Republik Indonesia Nomor 20 Tahun 2016 tentang merek dan indikasi geografis. The key provisions include Article 1 defines trademark as signs capable of distinguishing goods or services. Article 21 trademark registration can be rejected if it resembles an existing registered trademark. Article 83 allows trademark owner to file lawsuit against unauthorized use of similar marks. Lastly, Article 100 provides criminal sanction for trademark infringement. Individuals who intentionally use identical or substantially similar trademarks may face fines and imprisonment. Next, if we see from the international legal framework, trademark protection is also supported by Paris Convention for the Protection of Industrial Property. The relevant provisions are Article 6 bis, requires protection of well-known trademarks even if they are not registered in a particular country. It is relevant if a company attempts to use a confusingly similar name to OpenAI. Article 10 bis prohibits acts of unfair competition. It includes creating confusion regarding another company's business identity. Next, it is also supported by TRIPS agreements, or you can call it trade-related aspects of intellectual property rights. Their relevant provisions are Article 15, defines what may constitute a trademark. Article 16, number 1, grants trademarks owners exclusive right to prevent third parties from using identical or similar signs that may cause confusion. Article 16, number 2 and Article 16, number 3 provides additional protection for well-known trademarks. These agreements facilitate international trademark protection and enforcement. If we make comparison between the two cases, although both cases involve intellectual property rights, they protect different assets. The copyright case protects creative content such as articles, writings, and artistic works. The trademark case protects brand identity and consumer recognition. The New York Times case focuses on unauthorized use of creator works for AI training. The OpenAI trademark dispute focuses on consumer confusion caused by similar brand names. Both demonstrate the growing importance of intellectual property protection in the digital economy. In conclusion, intellectual property rights play a vital role in protecting creativity, innovation, and business identity. The New York Times versus OpenAI case illustrates the challenges copyright law faces in the age of artificial intelligence. Meanwhile, the OpenAI trademark dispute demonstrates the importance of protecting brand identity in a competitive global market. As future designers, creative professionals, and entrepreneurs, we must understand intellectual property rights not only as legal protections, but also as valuable strategic assets. By respecting copyrights and trademarks, we contribute to a more ethical, innovative, and sustainable creative industry. Thank you for watching.